Joint tenancy or tenancy in common. This choice can decide whether your children get a legacy. Now, we are going to talk about joint tenancy and tenancy in common today. What is a joint tenant or what is joint tenancy? Joint tenancy, in law we call it, the Latin term is jus accrescendi. It's the right of survivorship. It's when two or more persons own land together, but the tenancy will determine everything. If it's a joint tenancy, there is what we call a right of survivorship, meaning if one of the joint tenant dies, his or her interest goes to swell the interest of the survivor, right? So there is a right of survivorship. So if there are two persons, a husband and a wife on land, on a title for land, and the husband should die, then the wife automatically gets everything, all right? Now, this can be a little problematic, especially in our jurisprudence and in our jurisdiction, because people tend to like to leave their children with a legacy, with something. The Bible tells us that we should leave an inheritance for our children. So if that husband had children with a previous spouse, then those children, once the property he owns with his wife and he dies, those children will get nothing. So before you sign, please, I beg of you, ask the attorney or the person dealing with the property, whether it's NHT or whomever, what does it mean? Because you may be signing away your children's legacy. All right. So I've explained joint tenancy. I said there is jus accrescendi, there's a right of survivorship, and the survivor takes all when one of the joint tenants should die. That if there are three joint tenants and one should die, it means if there are three joint tenants, all three persons hold the property together, right? So the shares are not divided, so to speak. So if one of the three joint tenants should die, then the other two joint tenants would now have a half share of the property together, right? Would each have a half share of the property together. Now, tenancy in common or tenants in common. What is that? There is no right of survivorship. If one of the tenants in common should die, his or her interest goes to his or her estate. So the surviving tenant in common does not get any of the deceased tenant's estate or interest in the land. So the land stays with that person's estate, meaning they can will it and give it away to their children. Now, common situations where you have tenancy in common are situations where there are family land, where there are siblings, where there are business partnership and they purchase land together. People like to leave an inheritance for their children. So tenancy in common is usually the option here, where you would like to leave something for your children. But if you choose joint tenancy or you're a joint tenant, then nothing is left for your children, because when one joint tenant dies, that person's interest automatically goes to the surviving joint tenant. All right. I hope I've explained that so that people can understand. However, when you're dealing with, well, I'm assuming the title is a registered title. All right. Now, you still cannot sell the property when in a joint tenancy situation, even if one of the joint tenants should die, that person's name would still be on the title. So what is required to be done is a notation of death. So you find it is very common in Jamaica where a husband and a wife, they own property together, and one of the husband should die or the wife should die, and the property remains like that for many years, and then the survivor who gets all of the interest end up dying, and then the children are wondering, what should we do? Well, you will have to do a notation of death from the joint tenant dies. You do a notation of death when that person dies, while the other person is still alive. That's when you really should do it. And when that last person, the person who gets everything, dies, then the property will go to his or her estate now. So if that person leaves a will, you have to probate the will. If the person doesn't leave a will, you have to administer that person's estate. All right? So I'm going to go over it again as quickly as I can so you understand. In a joint tenancy situation, which is usually occur between husband and wife, the surviving joint tenant gets all the estate, all the interest of the deceased joint tenant, and nothing goes to the children of the deceased joint tenants. So if you have children and you are contemplating buying property with your wife or your husband, I would say think about it carefully. Do you wish your children to get your interest, or you wish your wife or your surviving husband to get everything? That is the joint tenancy situation. The children gets nothing when one of the joint tenants dies. Right? All right. Now, tenancy in common, it usually occurs when there are business partners, where there is family land, where there are siblings. People like to leave an inheritance for their children. So, in tenancy in common or tenants in common, you find that once one of the tenants in common dies, his or her interest goes to his or her estate. So that person can will his half share of the property to whomever he wishes. And it doesn't necessarily have to be half share. It can be a 1/3 share. One can have a 1/3, 2/3 share. Somebody can have a 1/5, 4/5 share, and so on and so forth. One can have 3/4 share, one can have a 1/4 share, or you can have a half and a half. It's usually expressed in fractions and not in percentages. All right? So there you have it for tenancy in common and joint tenancy situation in Jamaica. So think before you sign, because one signature can cost your children that legacy for life. Remember to share, like, and to follow. God bless you until we meet again. Amen.